it is obviously important that you get the legal structures right from the beginning so that everybody who is involved is on the same page, obviously, and that does prevent problems from cropping up down the road. There are two types of document that I want to touch on, which may be of interest to you. The first is what's commonly known as a property sharing agreement. This document is specifically designed to deal with all of the implications that come along with buying a property that's owned by more than one party, so it could be just two or it could be more. It's a very important document. The actual process of creating it obviously brings to light all the various issues that people should be discussing, and so hopefully it creates some discussion and then enables everyone to get onto the same page. The types of things that a property sharing agreement would cover are if people make different deposit contributions, then it's quite common that, for example, if I have two people who might have contributed slightly different deposit amounts, but they would like to pay the mortgage off equally, generally they'll own the property in separate half shares, but the property sharing agreement will state that if and when the property is sold, that the parties will get their respective deposits back and then split any capital gain after the balance of the mortgage is paid off. In other examples, if someone's got a really significantly bigger amount that they're putting in, you might not have equal shares. There's no particular circumstance or one size fits all. There's so many different circumstances, but generally we can accommodate all of them. From the point of view of groups of people borrowing from the bank, I think it is quite important to understand that in most instances, in terms of your liability to the bank as a group under the loan agreement, from the bank's perspective, each party will be responsible individually for the whole amount of the loan. But a property sharing agreement can regulate this as between the individual parties, so that, for example, if one party stuffs up and the others have to subsidise it and pay some of the mortgage for that person, the property sharing agreement will give a contractual right to enable the subsidising parties to get the money back from the defaulting party. Obviously, they set out maintenance and expenditure, all sorts of different things. It's very important they have a dispute resolution process in them, so that if there is a disagreement, then there's a prescribed way to deal with this. I think most importantly, probably, property sharing agreements set out a process of steps that have to be carried out in the event that one party wants to exit out of the partnership, or one party dies, for example. A typical scenario here would be that if one party wanted to exit the arrangement, they will give notice, and then this would trigger an option from the remaining parties to buy out that person's share if they could, and that would be at a registered market value. And then if the remaining parties couldn't or didn't want to do that, then it either might trigger an option to the exiting party to buy the whole property, or the property would then be placed on the market for sale. So that's just a little example of a typical scenario. And the second type of legal document I want to mention is not a very romantic one, but it's contracting out agreements, commonly known in the olden days as prenups. Most of you probably already know that the presumptions in the Property Relationships Act, whereby assets are accumulated during a relationship, are split 50-50, and that applies whether you are married or in a de facto relationship. And even if you've been in a relationship for less than 3 years, that doesn't mean that the Act won't apply. And another common misperception is that if one party has all of their assets in a trust, then those assets will be protected, but that's not necessarily the case either. So the only way to get around this is to have a properly prepared contracting out agreement. Sometimes people come in and they've just done their own little thing and signed it, but you need to have lawyers involved, otherwise it doesn't contract you out of the provisions of the Act. In some ways, if you both start out with not much, then one bonus of that is that you probably don't need a contracting out agreement. But obviously for people who have different assets or it's a second time round type relationship, this is obviously quite a tricky area to navigate, and obviously you don't want to ostracise your partner by broaching a contracting out agreement such that you don't actually have a relationship to have a contracting out agreement with. So if you're interested, I won't go into the details of contracting out agreements, it's boring. I did want to just mention that how property sharing agreements and contracting out agreements interlink is that if a couple, a de facto or married couple, have a property together and they're also having a contracting out agreement, then more often than not, all of the things that have been taken into account for a PSA, all of those considerations would be incorporated into a contracting out agreement. So that's how they sort of interlink. But at the same time, it is really important to understand that if you're in a de facto relationship or married, then if you've got a property sharing agreement, that doesn't mean that that will override the provisions of the Property Relationships Act. So even if it says, if we break up, A gets this amount and B gets this amount, that could all go down the drain if one party makes a claim under the PRA. And just one other point I'd like to make in respect of the relevance of contracting out agreements for group buying situations, and when you've got parents gifting money especially. A lot of parents gift money, as I said, to their son and daughter, who then might turn around and buy a house with their partner. And that money will also be subject to the 50-50 split assumptions in the PRA. And so having a legally binding contracting out agreement is the only way to protect that money in the event of a split. And that is something that has caused a lot of families, when a partnership breaks up, quite a lot of angst. So in conclusion, obviously the ideas that I've talked about is just the very basic framework. Every situation is different, but we can tailor particular solutions depending on people's circumstances. And I guess we don't need to pretend that drafting up legal paperwork is the most exciting part of buying a property. I'm sure that lots of my clients would much rather spend it on a couch than some legal documents, but it is really, really important that you get a lawyer and other professionals involved early on in the process, especially if you're seriously considering this kind of joint ownership structure as an option. We all genuinely want to make the process as painless as possible, and not all lawyers are fuddy-duddy, bald old men. I will be sticking around at the end, so please do come up and chat with me if you'd like, or even give me a call if you don't get a chance to speak with me tonight, to have a preliminary chat, and I promise I won't send you a bill. Thank you.